The role of the victim is different in a civil lawsuit than in a criminal case. In a civil lawsuit, the victim is the plaintiff, who is directly bringing the suit against the defendant. In a criminal case, the victim is actually considered a witness to the crime, but does not generally have the power to bring charges against the defendant. That role instead is given to the prosecutor. The prosecutor is a lawyer who works for the state. Prosecutors are given an immense amount of power when it comes to their decision of whether or not to charge a case. This power is called prosecutorial discretion, and there is very little oversight involved. Essentially, it is up to each individual prosecutor as to whether or not they want to charge each individual case that they are given. The standard of proof for charging a case is probable cause. So the prosecutor must believe that he or she has enough probable cause to charge the case, and usually prosecutors are also required to believe that they will have enough evidence to prove to a jury that the defendant is guilty beyond a reasonable doubt. So what is the legal definition of rape or sexual assault according to statute? Well, it depends on the state. In fact, the legal definitions vary so widely that it makes it difficult to collect and compare crime data for sexual assault across all the states. So Minnesota has all of its statutes available online. You can go directly to their website where all the statutes are listed and just scroll directly to the sex crimes section. This section of criminal law covers bestiality, prostitution. So the section that we are most interested in is this one down here. Minnesota doesn't use the terms rape or sexual assault. Instead, the legal definition of the crime is criminal sexual conduct, which is separated into 5th to 1st degrees. The degrees are determined by factors such as victim age, whether it was sexual contact or sexual penetration, whether force or coercion was involved, whether the victim was incapacitated, whether or not there was injury to the victim, whether a weapon was used, whether there was an accomplice, and whether the victim had reason to fear for imminent great bodily harm. Also of note is that personal injury to the victim includes not just physical injury, but also severe mental anguish or pregnancy. Minnesota is an affirmative consent state, which means that consent must be given through words or overt actions by the person indicating a freely given present agreement to perform a particular sexual act with the actor. Present meaning that consent can be withdrawn at any time. So someone can consent to a sexual act and then in the middle of it withdraw consent. Affirmative consent meaning that the overt words or actions must indicate this freely given present agreement. So freely given meaning that it cannot be coerced. Rape or sexual assault in the past was often defined by the victim having to resist in some manner, or verbally or physically protest. With affirmative consent, that is not required. Affirmative consent basically assumes that the default state of any person is not consenting to sexual contact, not that the default state is consenting to sexual contact. What this means is that if the victim did not say anything at all, or if they do not show through their overt actions that they are wanting the sexual act, they are not presumed to be consenting. So it is not enough for the defendant to say that the victim did not protest. The defense must be that the defendant reasonably assumed through the complainant's words or overt actions that they were consenting to this act. If someone seems unsure or hesitant, then they are presumed to be not consenting. Also of note is that marital rape was criminalized in Minnesota in 2019. So prior to that, it was not illegal to rape your wife. It was a bit surprising to me that this change in statute happened so late, but we're glad that it did. And as of now, marital rape is illegal in the state of Minnesota. Also of note is that as of 2021, when a victim is voluntarily incapacitated due to alcohol or drugs, they are considered unable to give consent, which means that having sex with such a person is considered criminal sexual conduct. An unconscious person is also considered not able to give consent. As we see down here, someone who is physically helpless includes someone who is asleep or unconscious. I recommend looking at the statutes in your own state to find out what the specific laws are regarding criminal sexual conduct. Let's talk about evidence. So in a criminal case, the prosecution has what is called the burden of proof, which means that it is up to them to prove that the defendant committed the crime. In a civil case, similarly, the person who is bringing the lawsuit against the defendant has the burden of proof and has to prove that the defendant is liable for damages. I do want to note here, because it is significant, that because of the Fifth Amendment, the defendant in a criminal case does not have to say anything. And in fact, most defendants do not say anything. As I understand it, defense lawyers tell their clients not to talk about the case to anyone. Friends, family, and most definitely not the victim. So while the victim in a sexual assault case is expected to testify, and indeed most of these cases really don't proceed without the victim's testimony, the defendant is not expected and most of the time does not testify in his defense. So the prosecution proves their case through evidence. And what is evidence exactly? Well, evidence is anything that proves a fact of the crime. Each piece of evidence in and of itself does not have to prove the entirety of the crime. Evidence only has to prove or suggest an element of the crime. So for instance, in a sexual assault case, the victim may have had a rape kit done, which may have given her DNA evidence that she and the defendant did in fact have sex. This is evidence in support of one element of the crime, but the prosecution must prove all elements of the crime. Just because sexual activity is confirmed does not mean that it was criminal sexual conduct. If the victim was an adult, then the prosecution still must prove that the victim was not consenting to the sexual activity. Something that many people seem to get confused by is the fact that the victim's testimony is actually evidence. So if the victim testifies and the encounter that she describes with the defendant meets all of the elements of the legal definition of criminal sexual conduct, then that is actually enough evidence to charge and convict the defendant of criminal sexual conduct. Evidence can be categorized into direct evidence and indirect evidence. Indirect evidence also being described as circumstantial evidence. Direct evidence would be something like an eyewitness who directly witnessed the crime happening. This includes the victim's testimony, or a video recording of it happening, or an audio recording of it happening, or a recorded confession from the defendant, or even a recorded admission of guilt from the defendant. An admission of guilt can establish an element of the crime. For instance, if the defendant admitted to having sex with the victim. A confession is usually more detailed than an admission of guilt and includes an admission to all the elements of the crime. Circumstantial evidence is evidence that requires inference to connect a fact. For instance, if someone sees the defendant fleeing the scene. It can also be the emotional state of the victim before and after the event occurred. Physical evidence are things that are tangible. So blood or DNA is considered physical evidence. Weapons, torn clothing, photographs of injuries. This is all considered physical evidence. Other kinds of evidence that can help to suggest or prove the crime are records, medical records, texts, and something that I actually didn't know until recently was used as evidence, which is journal entries. Anything that is written down by the victim or the defendant or witnesses around the time of the crime can be used as evidence. Another kind of evidence which is often used in sexual assault cases is expert witness testimony. An expert witness is someone who is qualified to speak on subjects such as victim behavior or perpetrator behavior. Oftentimes, expert witnesses are used in court to explain a victim's behavior that the jury might not understand well because of rape myths. Another kind of witness is a character witness. A character witness can be used to testify about the good character of the defendant. Character witnesses can also be used for victims. And another piece of evidence that I forgot to mention earlier is that if a victim has ongoing trauma from the incident, which is often the case, then her medical records of seeing a therapist or psychiatrist can also be used as evidence. There are a lot of complicated rules in law as to what evidence is permissible in court. It is up to the judge to determine which evidence is admissible and which is not. For instance, if evidence is illegally obtained, so if the police were to enter the suspect's house and discovered evidence, but they did so without obtaining a search warrant first, then that evidence might be considered illegally obtained and might not be permitted in the trial. There are strict rules around using confessions as evidence. There is a burden placed on the prosecutor to prove that the confession was not coerced. And the reason for that is because the world has a history of obtaining confessions from suspects in extremely immoral ways through tactics such as coercion and torture. This unfortunately led to many false confessions. So to safeguard against that, the prosecution must prove that any confession that they use as evidence was not obtained through any coercive measures. I do want to note here that it is terribly ironic that in our justice system, we safeguard so heavily against false confessions, and yet we use so widely the practice of plea bargaining, which is basically coercing the defendant into pleading guilty in exchange for a less severe sentence. So when does the collection of evidence happen? Collecting evidence can happen at any stage during the justice process. Most of evidence collection is done by the investigator on the case, but in cases of sexual assault especially, we see that most of the responsibility of evidence collection is actually placed on the victim's shoulders. Prosecutors can and sometimes do continue to collect evidence even after a case is charged. In civil cases, after the complaint has been served and the lawsuit has begun, the two parties then enter a phase called discovery. During discovery, there is a fairly broad sharing of evidence between the parties. Usually, if the parties' lawyers are in possession of evidence, they voluntarily exchange that evidence, and if not, one party's lawyer can subpoena the other party's lawyer for the desired evidence. Let's talk about the statute of limitations. So the statute of limitations is basically a time limit. For criminal cases, it's the time limit for when charges can be filed against the defendant. In civil law, it's the time limit for starting a civil lawsuit against the defendant. Historically, the statute of limitations was a huge barrier to sexual assault cases because there are so many victims who don't report their assault until months or even years later. Also, there are cases where the victim may have reported the assault immediately, but the investigators or the prosecutor don't decide to do anything about it for years or sometimes even decades later. So I did want to point that out because it is not always the victim's fault for not reporting immediately that charges are not filed for years. The statutes of limitations are different depending on the state and also different depending on the crime committed. In the state of Minnesota, the statute of limitations for criminal sexual conduct cases has now been eliminated, so charges can be filed at any time after the assault. For civil cases, the statute of limitations for rape in Minnesota is 6 years. I encourage you to look up the statute of limitations in your own state. Something else about recorded evidence that I forgot to mention earlier is that there are different rules in different states about who has to know and be consenting to the recording happening. So for instance, in some states, all parties present who are being recorded need to have consented to that recording in order for it to be admissible in court. In Minnesota, only one party needs to be consenting. So whoever is making the recording is the only person present who has to consent to that. When collecting evidence, sometimes it's necessary that the police or the prosecutor will apply for a search warrant. The standard of proof for search warrants is probable cause. So the person applying for the search warrant will need to be able to provide to the judge evidence enough to fulfill that they have probable cause to believe that evidence of this crime will be found in this location.